Greetings and salutations. This is Brian Jarris, CFP from Ville Wealth Management. In today's video, we're going to cover 10 important asset titling questions. At Ville Wealth Management, we believe how you title your assets is just as important as the investments you choose or the plan that you follow. Done right, you can avoid probate, minimize taxes, and make sure your assets go to the proper loved ones. Done wrong, you could create confusion, delays, and even legal disputes. Now, I've run planning at 2 top private banks the past 20 years. I want to share what I've learned with you to help you avoid costly mistakes. Ville Wealth videos are meant to be educational only, so if you need customized advice tailored for your situation, please reach out to me at villewealth.com.
Question number 1, what assets avoid probate? Well, jointly owned assets would avoid probate. Assets that you've named a beneficiary, such as your retirement accounts, 401ks, 403bs, IRAs, your insurance policies, even deferred compensation plans. Assets like bank accounts or investment accounts where you've created a transfer on death or payable on death designation, or assets that are held in a trust. Question number 2. What are some common mistakes with asset titling? Well, not updating your titling after major life events like marriages, divorces, births, deaths, or even moving to another state. Having old beneficiary forms. Maybe you still have named an ex-spouse as a beneficiary. Not properly funding your trust. Naming a non-spouse as a joint owner on one of your accounts, like one of your adult children. That can expose you to their creditors as well as even their marital issues. Question number 3, what are some asset titling best practices? Well, number 1 is let's just make sure we're reviewing your asset titling and your beneficiary forms on a regular basis. Matter of fact, create a list of all of your assets from your homes, your bank accounts, investment accounts, businesses, even your digital accounts like rewards accounts or cryptocurrency. Make sure you're reviewing the asset titling and the beneficiary designations on all of those, and you understand how they're going to pass, whether it's through the designations or whether it's through your trust or whether it's even through your will. And make sure that all of that is coordinated with your estate plan. Definitely make sure that you're working with an estate planning attorney to coordinate that all of these things are working together.
Question number 4, if we've updated our asset titling and beneficiary designations properly, then why do we still need a will? Because a will can really act like a great safety net for any assets or accounts maybe we overlooked. Second, it can help you name a guardian if you have minor children. Otherwise, the court will decide. It can also help you name an executor to manage your estate, pay your debts, and distribute your assets. Lastly, there's some personal assets that can help facilitate, like jewelry or family heirlooms that don't have titling or beneficiary designation forms. Lastly, here's a nice chart that talks about the asset types and whether they go through your will and have to go through probate or not. Question number 5, should minors serve as beneficiaries? Well, typically not. You might want to use a trust or custodial accounts, mainly because minors can't manage financial assets until they reach that state's age of majority, which typically is 18 or 21. And so what you really want to do is, again, use a custodial account or a trust. Kind of a workaround here is if you have a beneficiary form and you want to put the minor, you can appoint a custodian on that form by saying something like John Smith as custodian for that minor, Jane Smith, under the Ohio Uniform Transfer to Minors Act. Question number 6, how do you handle asset titling for a house? Well, if you're married, typically you would title it joint tenancy with right of survivorship. That way, when the first spouse passes away, the second surviving spouse would continue on with ownership. Now, some states offer tenancy by the entirety. Here are the states that offer that. The advantage with this one is that it has better creditor protection. So the creditor would need to have a judgment against both spouses in order to try to claim that property. Now, if you live in a community property state, you should do community property with rights of survivorship. The benefit there is you can get a full step up in basis. Now, if you're trying to pass the residence to the next generation and you want to avoid probate, you can either do a transfer of death deed or you can put it in your revocable living trust. Question number 7, how do you handle titling of automobiles? Well, most states allow you to utilize a transfer of death or beneficiary designation added to your title of your car in order to pass it on to your children or other beneficiaries. Now, here are the current list of states that do not permit it. In those states, you would either utilize a revocable living trust or utilize your will, where unfortunately it would go through probate. Now in Ohio, you can just go to the BMV, fill out BMV 3811 in order to add that to your title for the transfer of death designation, and it's a small fee. Question number 8, what are some reasons you might want to consider naming a trust as a beneficiary to a retirement account? Well, maybe you're trying to protect minor children. Maybe you're dealing with a special needs or a financially irresponsible heir. Maybe you're in a blended family or you're dealing with a complex situation. Maybe it's just asset protection. Just make sure if you are utilizing a trust that you make sure you set it up as a see-through trust to make sure you maintain the tax benefits. Question number 9, what are some reasons to not name a trust as a beneficiary to retirement accounts? Well, if you don't set the trust up properly as a see-through trust, your heirs may end up pulling that money out within 5 years versus 10 years, creating more taxes right away. Also, your beneficiaries would have less flexibility. The taxes inside of a trust can hit the 37% tax bracket at just $15,200 in 2025 for income that stays in the trust. There is definitely more administration, more complex administration, and more cost to a trust than not utilizing a trust. Question number 10, what are some ways to title assets to reduce taxes? Kind of 3 main areas I want to talk about. One is there are asset titling strategies to help avoid probate. Here's a list of those. There are ways to get a step up in basis at the first death or second death, as well as there are some states that have state estate tax, and inheritance taxes. Here are the lists of those states. So you want to be mindful and have strategies that really take into account these 3 main areas. Thanks for watching this video. This is Brian Jarris, CFP from Ville Wealth Management. If you want to get a hold of me or you want to see more information on asset titling or other topics, please go out to villewealth.com. Thank you and have a great week.